Book 2, Chapter 3, Part 4 of History of the Inquisition of Spain, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. History of the Inquisition of Spain, Volume 1, by Charles LEA. Book 2, Chapter 3, Privileges and Exemptions, Part 4. Even more fruitful of trouble was the fact that it was impossible to make the inquisitors respect the limitations imposed by the Concordias on the number of familiars, and consequently to obey the rule of furnishing lists of them to the authorities so that they might be known. Appointments were lavished greatly in excess of all possible needs and without informing the magistrates, often, indeed, without keeping records in the archives. The familiar might or might not carry with him the evidence of his official character, but, whether he did so or not, his arrest or disarmament was violently resented, and the ordinary citizen, when caught offending, was apt to claim that he was a familiar in hopes of being released. How exasperating to the civil authorities was the situation may be gathered from a case occurring in Barcelona in 1568. The veguer, on his nightly rounds, arrested Franco Foix, whom he found armed with a coat of mail, sword, buckler, and dagger. The culprit claimed to be a familiar, and the veguer obediently handed him over to the tribunal. He proved not to be one, but instead of returning him, the inquisitors fined him in 44 reales for their own benefit, presumably as a penalty for personating an official, and restored him his forfeited arms. When the laws were thus openly set at defiance, conditions were eminently favorable for quarrels, even without the violent and mutual animosity everywhere existing between the tribunals and the civil authorities. Collisions were correspondingly frequent, and were fought to the bitter end. It would be wearisome to multiply cases illustrating the various phases of these quarrels which occupied the attention of the king and his councils in their settlement. A single one will suffice to show the spirit in which they were conducted on both sides. In 1620, by order of the Tribunal of Valencia, acting in its secular capacity and not in a matter of faith, the commissioner at Jativa arrested a man and sent him to Valencia under the customary guard of relays of familiars. One of these, named Juan Lopez, armed with a prohibited flintlock, was conveying him, on February 23rd, when, at Cartaroja, about a league from the city, some armed alguaziles, in the service of Dr. Pedro Juan Rejuale, a judge on the criminal side of the audiencia, arrested him, taking away his weapon and carrying him to Dr. Rejuale's house. Disregarding his documents, Rejuale told him that he could not be released without giving bail to present himself to the viceroy, and, as he was unable to furnish it, he was handed as a prisoner to the local magistrates. On learning the event, the inquisitors applied to the regent of the audiencia, who ordered the release of Lopez, which was effected, and Rejuale visited the tribunal, admitted that he had been in error, and promised in future to observe all necessary respect. In spite of this, the inquisitors proceeded to try him for impeding the Inquisition, ordered him to keep his house as a prison under pain of 300 ducats, and threw into the secret prison, as though they were heretics, the 4 alguaziles who had made the arrest. When notice of this was served on Rejuale, he protested that the inquisitors were not his judges and that he would appeal, whereupon the additional indignity was inflicted upon him of posting 2 guards in his house with orders to keep him in sight. This produced a crisis. The viceroy assembled in his palace all 3 salas, or branches of the audiencia, where the matter was fully discussed, and it was resolved to release Rejuale and hold the 2 guards as hostages for the imprisoned alguaziles. At 2 a.m. Dr. Morla went with halberdiers, furnished by the viceroy, seized and handcuffed the guards, and brought Rejuale to his brother judges. At the same time, a scrivener of the court had been sent to the inquisitor Salazar, with a message from the viceroy to the effect that, as the offence had not been in a matter of faith, Rejuale was justiciable only by the king. If the Inquisition held otherwise, a competencia could be formed. The Audiencia had decided that Rejuale and the alguaziles must be released, and the guards be held until this was done. The scrivener also presented a petition of appeal to the pope, or to whomever was judge, and demanded apostolos, or letters to that effect. To this, Salazar replied in writing that the arrests had been made for matters incident to and dependent upon matters of faith, in which the Inquisition had exclusive jurisdiction, and could admit no competencia. He could say no more as to the cause of the arrests without violating the secrecy of the Inquisition and incurring excommunication, and he begged the viceroy not to interfere in a matter concerning so greatly the service of God and the king. At 4 a.m. the scrivener returned with this reply to where the viceroy and judges were waiting. At the magic word faith, however fraudulently employed, all opposition vanished. By 6 o'clock, Dr. Morla had taken Rejuale back to his house and had replaced the guards, and, at the same time, the scrivener bore to the inquisitors a note from the viceroy saying that, as they had certified that it was a matter of faith, the Audiencia had restored everything to its previous condition, and he offered not only not to impede the Inquisition, but to show it all aid and favor. The case was thus transferred to the court, where the Suprema on one side and the Council of Aragon on the other struggled for a favorable decision from Philip III. The former evidently felt the weakness of the claim that the faith was involved, but it argued that impeding the Inquisition in any way conferred jurisdiction on it, and Aliaga, in his double capacity of Inquisitor-General and royal confessor, added a bitter complaint as to the manner in which the Inquisition was abused and maltreated. To this, the king replied that he wished the affair treated with the customary moderation and mercy of the Holy Office, especially as it was not directly a matter of faith, and whatever sentence the Suprema resolved upon for Rejuale and the other inculpated parties must be submitted to him before publication. Besides, he ordered a junta of 2 members each of the Suprema and the Council of Aragon to be formed, and to devise a plan for the avoidance of future contention. This assumed Rejuale's guilt and awarded the victory to the Suprema, but it was not satisfied and presented a consulta representing the perilous condition of the Valencia tribunal, which necessitated the punishment of the delinquents as a warning, but Philip merely repeated his former decision. What was Rejuale's fate we have no means of knowing, but his career was evidently blasted, whatever may have been the so-called mercy exhibited. As for the perilous position of the tribunal insisted on by the Suprema, it seems to be set forth in a petition of the syndic of the College of Familiars, February 25, 1616, complaining of arrests and ill treatment, and asking the tribunal to take evidence on the subject. It accordingly did so, but while the testimony was ample as to the existence of ill feeling towards the familiars, in substance it amounted only to their being deprived at night of daggers and bucklers, which were prohibited weapons, and it does not appear that any action was taken in consequence. Complaints continued, and another petition of October 30, 1626, asked that an envoy be sent to the Suprema, for which the familiars would defray the cost, for unless some relief was had they would resign in a body, as their position only exposed them to wrong and insult, and their privileges were set at naught. The difficulty of enforcing the laws on the people was intensified by the privileges claimed by the familiars. They were by no means peaceable folk, and the unprivileged class naturally regarded it as a hardship to be restricted to the use of swords when these gentry were so much more efficiently armed. The Suprema, as a rule, supported its satellites. For 10 years, from 1574, it resisted, in Aragon, the enforcement on familiars of a royal decree against carrying prohibited weapons at night, although the Concordia of Aragon in 1568 provided that familiars should obey the laws respecting arms, and that inquisitors should not protect them in violations. Members of all royal councils were involved in the discussion, as though it were the weightiest affair of state, and it was not until 1584 that the Suprema was induced to issue the necessary orders, which it was obliged to repeat in 1592. Another illustration of its attitude occurs with respect to the Pragmatica of great severity against the use of firearms, issued by Philip III, March 14, 1613, pronouncing the mere discharge of a weapon to be a capital offense, whether death ensued or not. It abrogated all privileges and exemptions, and conferred on the royal courts full jurisdiction in such cases, and all this was accepted and its observance enjoined by the Suprema. This met with such scant obedience that the Council of Aragon, in a consulta of July 31, 1632, called the king's attention to the evils existing from the exemption of familiars, and suggested that they should not be permitted to decline the jurisdiction of the courts for crimes committed with firearms. It was doubtless in consequence of opposition by the Suprema that it was not until September 30, 1633, that Philip IV, in a cedula addressed to the Viceroy of Valencia, ordered that, with the assent of the councils of Aragon and of the Inquisition, the Pragmatica of 1613 must be strictly observed, by which all exemptions were disallowed, and all offenders were triable and punishable by the royal courts. The Inquisition must withdraw from all pending competencias, and the cases be carried to conclusion by the Audiencia. The Suprema must have consented unwillingly to this, for it labored with the wavering monarch and, on November 8th, he wrote, withdrawing the cedula and ordering the suspension of all cases before the Audiencia. A few weeks later he yielded to other influences and annulled the last letter, but added that his orders of September 30th must be executed impartially, for the Inquisition complained that it was enforced only against its officials, and in such cases he would give it a free hand again. December 27th, the Suprema sent this to the Valencia tribunal with formal instructions to obey it, but added a confidential letter saying that efforts would not be relaxed to persuade the king to remit all such cases back to them. Meanwhile, an agreement had been obtained from the Council of Aragon that all sentences by the Audiencia should be referred to it before execution, and the tribunal must watch them closely and send such reports as would enable the Suprema to obtain favorable action on them. For this endless strife, for the habitual disregard of the laws by familiars, the Suprema was primarily responsible. It was perfectly acquainted with the innumerable edicts specifying prohibited weapons and forbidding the carrying of them after nightfall. It acquiesced, ostensibly at least, in the subjection of these offences to the royal courts, and yet it encouraged familiars in the belief that it had power to override all laws and could confer license to violate them. The formula of commission which it caused to be issued to familiars contained a clause granting them full liberty to carry arms, offensive and defensive, publicly and secretly, by day or by night, and ordering all secular officials to abstain from interference with them, in virtue of holy obedience, and under penalty of excommunication and of 50,000 maravedis, applicable to the expenses of the Holy Office. It could not be fuller or more explicit. There are no exceptions as to the character of arms or allusion to the jurisdiction in these cases granted by the king to the royal courts. When one branch of government thus resolutely placed itself in opposition to the sovereign and encouraged its subordinates to resist the laws and the constituted authorities, peace was impossible and conflicts were inevitable. Yet the illegality of all this was admitted when, in 1634, the familiars of Valencia held a meeting to assess themselves for a donation to be offered to the king in return for a privilege to bear arms, and the Suprema instructed the tribunal to aid the movement, and again when, in 1638, a fruitless offer was made by them of 12,000 ducats for the revocation of legislation on the subject. To crown all this, the Suprema, in 1657, reached the audacity of arguing that the right of familiars to bear arms was imprescriptible and could not be abrogated by any prince, for it would impede the Inquisition in the free exercise of its functions. Wherefore it denied that any competencia could be formed in such cases. The secular authorities had no jurisdiction, and there could not even be a discussion about their claim to interfere. Philip IV had the weakness to submit to these extravagant claims in 1658, and to decide that the Suprema alone had cognizance in such matters. The case in which this occurred was that of Jaime Espejo, alcaide of the penitential prison of Valencia, arrested for carrying pistols, and it has interest for us because in it the inquisitor Don Antonio de Ayala Verganza argues away all the royal decrees and pragmaticas as not meaning what they had said, and proves it by citing a vast number of cases in which, when carried up to the king, he overruled his own legislation, invariably deciding in favor of the Inquisition and against his own jurisdiction. He could sometimes be brought to issue wholesome general regulations, but, when it came to their execution, the ever-present dread of interfering with the service of God overwhelmed him. Yet Philip promptly reversed himself, for, in a despairing effort to put an end to these interminable quarrels, he was induced to issue a royal letter, December 23, 1659, declaring that the cognizance of infractions of the laws respecting prohibited arms lay with the royal jurisdiction, and that no competencias should be formed in these cases. When this letter was alleged by the royal court, in the case then pending of Joseph Navarro, a familiar arrested for carrying a pistol, the Inquisition in reply airily cast aside the pragmatica of 1613 and its confirmation of 1633, by asserting that both before and after those laws it had always exercised jurisdiction over these cases, as was notorious to every one, which was all doubtless true. As for the recent letter of 1659, it had not been issued with the assent of the Suprema. Being thus irregularly issued, it should not be regarded as valid until the king should be supplicated to modify it, and until this was done, the accused should be surrendered to it, or he could be released under bail to both jurisdictions. The vacillating monarch probably yielded again. Whether he did so or not mattered little to the Holy Office, which regarded his decrees so lightly. The miserable business of quarreling over the multiplication of the laws went on, and, in 1691, Carlos II found it necessary again to prohibit the carrying of pistols and armas cortas, and to deprive offenders of their claims to jurisdiction, even if they were familiars or salaried officials of the Inquisition. Several cases in the earlier years of Philip V seem to indicate that this matter was an exception to the general limitation of the privileges of the Holy Office, and that there was a tendency to admit its claims. Their final extinction, however, was not far off. In 1748, Fernando VI prohibited all officials of tribunals, including the Inquisition, from carrying cut and thrust weapons of any kind. Exclusive jurisdiction in the enforcement of this was reserved for the secular courts, and all claims to fuero were abolished. He confirmed and extended this by proclamations of 1749, 1751, and 1754, with penalties of 6 years in the mines for commoners and 6 years' service in presidio for nobles. In another of 1757, he regretted the non-observance of these laws and ordered their irremissible enforcement without privilege of fuero. This legislation was supplemented by Carlos III in 1761, who included in the prohibition all firearms of less than 4 palms length of barrel, although he conceded to gentlemen the use of holster pistols when on horseback, but not when on muleback. Yet the Inquisition continued to issue the old form of commissions granting unlimited license, until the magistrates of Seville and Alcalá la Real refused to recognize them, when, in 1777, it admitted its altered position by a modification which granted the right to carry non-prohibited weapons, but only when on duty for the Holy Office, and contented itself with exhorting the secular authorities not to interfere with this. In somewhat ludicrous contrast with the belligerent spirit, indicated by the earnest desire to carry arms, was the claim that all connected with the Inquisition were exempt from military service. In its relations with the state, the Holy Office recognized no duties of citizenship, it only claimed privileges. That the salaried officials regularly employed in the tribunals should enjoy such exemptions was merely in accordance with old custom, for a law of Juan II in 1432 specifically released from the obligation of service nearly all officials, including even physicians, surgeons, and schoolmasters. That this should apply to the Inquisition seems to have been assumed as a matter of course in its early days, but in 1560 the corregidor of Cordova summoned the officials and familiars to appear in the musters. They all claimed exemption when the Inquisitor-General upheld the appeal of the officials, but denied that of the familiars. Similar questions arose in Murcia in 1563 and 1575, in which a similar distinction was drawn. In Valencia, the familiars had probably been more successful, for an article in the Concordia of 1568 provides that they must serve their terms in guarding the coasts, and that inquisitors shall not defend them in seeking exemptions under pretext of their office. The same question arose in Majorca, and was settled by a law providing that familiars refusing to perform guard duty on their appointed days could be compelled by the royal officials. Thus, by common consent at this time, salaried officials were exempted, while the claims of familiars were rejected. In the troubles of the 17th century, when the very existence of Spain was threatened, the question as to officials as well as familiars came up again, and the Suprema sought to protect both classes. In 1636 and 1638, the corregidors of various cities refused to accept the officials when making up the lists for conscription, but Philip IV decided that they were exempt. As the danger increased, in 1640, with the rebellions of Catalonia and Portugal, and the resources of the kingdom were strained to their utmost, all claims were disregarded. By a cedula of September 7, 1641, Philip declared this to be a religious war, as the rebels were allied with nations infected with heresy. Inquisitor-General Sotomayor was required to summon all officials and familiars to organize and serve, and was clothed with power to enforce it. No protest was made against this, for it was a financial rather than a military move. Arrangements were made to commute service for cash, and the Suprema was thus aided in meeting the royal demands for contributions. This was only a temporary truce. Philip, in a letter of February 22, 1644, to Inquisitor-General Arci y Reynoso, reported that the attitude of the officials had excited much dissatisfaction in Galicia. He therefore ordered that no exemptions be admitted and no excuses be received. To this the Suprema responded with bitter complaints that in Saragossa the lot had fallen on a messenger of the tribunal and the widow of a notary, who were told that they must furnish substitutes, all of which was in violation of the privileges of the Inquisition, crippling it in its pious labors so essential to the faith, and reducing it in popular esteem to a level with other institutions. Unstable as usual where the Holy Office was concerned, Philip abandoned his position and admitted that salaried officials were not liable to serve or furnish substitutes, which the Suprema promptly conveyed to the tribunals, cautioning them not to employ excommunication in collisions with the royal officials until after obtaining its permission. Even in this hour of supreme need, the liability of familiars was contested. Philip endeavored to placate the Suprema by assigning them to garrison duty, but it remonstrated, asserting that the Inquisition could not perform its functions if wholly deprived of them, and the cause of religion was higher than any other. It therefore asked that no place should be left without one. In small towns there should be 2, and in larger places 4. To this Philip assented, on condition that those exempted should contribute to those who served. But the Suprema demurred. Everyone could avoid service who could pay the assessment, so this would be giving the familiars no special privileges. There could be no question that favors shown to the Inquisition would contribute to success in the war, for experience had demonstrated that the more sovereigns had fostered it, the more fortunate they had been. However just was the argument, it was fruitless. Philip adhered to his decision, but when the corresponding decrees were issued, the Council of Castile remonstrated in its turn, and the distracted monarch was involved in a fresh discussion between the two. The Suprema carried its point that those exempted should not contribute to those conscripted, and the arrangement remained in force. It was repeated in a Carta Acordada of January 14, 1668, and when, in 1681, a question arose in Tembleque, the Suprema cautioned the Toledo tribunal not to issue more letters of exemption than the settlement permitted, in order to avoid competencias, which only served to render the Holy Office hateful and to imperil its other privileges. Carlos III seems to have been more liberal when, in 1767, he included, in an elaborate list of those exempt from military service, the ministers and dependents of the Inquisition who were relieved from billets under the decree of May 26, 1728, which, it will be remembered, granted the privilege to the number of familiars allowed under the old Concordias. Carlos IV was more exacting, for in 1800, when regulating the conscription in minute detail, he granted exemption only to the titular officials and took special care to exclude familiars and other dependents. This continued to the end. September 14, 1818, the Suprema communicated to the tribunals a decision of the king that, in order to secure exemption from conscription, it was not necessary to exhibit a royal commission, but one from the Inquisitor-General or Suprema sufficed. Evidently, the local tribunals were no longer allowed to issue certificates of exemptions. End of Book 2, Chapter 3, Part 4.